When individuals become employees, they take on both employment rights and responsibilities. Those obligations can be spelled out formally in a written employment contract or more likely in an employer handbook and policies disseminated to employees. Contracts formalize the employment relationship. An employee's contractual rights are based on a specified contract with the employer. For instance, a union and an employer negotiate a labor contract that specifies the terms, conditions, and rights that employees who are represented by the union have with the organization. The contract also spells out the company's rights and obligations. Traditionally, executives and senior managers have negotiated individual employment contracts, but they are now becoming more common for highly specialized professional and technical employees who have scarce skills. An employment contract is a formal agreement that outlines the details of employment. An employment agreement should address all particulars of the employment relationship, including base pay and incentive compensation, basic and supplementary benefits and prerequisites, key job functions and performance criteria, the contract term, and terms and conditions for terminating employment. Employment contracts may include non-compete agreements, which prohibit individuals who leave an organization from working with an employer in the same line of business for a specified period of time. A non-compete agreement may be presented as a separate contract or as a clause in an employment contract. The courts use the following guidelines to determine whether a particular non-compete agreement is acceptable. First, it sets limits on the expectations of employees not looking for work elsewhere. A typical duration is under 2 years, restricts activity to a logical geographic scope, grants employees additional consideration beyond regular employment, limits employers from working within the current area of specialization, but does not prohibit employment in new fields. Contracts may also include non-piracy agreements, which bar former employers from soliciting business from former customers and clients for a specified period of time. Clauses requiring non-solicitation of current employees can be incorporated into an employment agreement. These limitations are created to protect the organization from former employees attempting to recruit former coworkers or clients, essentially poaching talent or business. An area often covered in employment contracts is protection of intellectual property and trade secrets. A 1996 law made theft of trade secrets a federal crime, punishable by a fine of up to $5 million and 15 years in jail. Employer rights in this area include the following: the right to keep trade secrets confidential, the right to have employees bring business opportunities to the employer first before pursuing them elsewhere, a common law copyright for works and other documents prepared by employees for their employers. The rights and responsibilities of the employee may exist only as unwritten employer expectations about what is acceptable behavior or performance on the part of the employee. Some court decisions have held that if an employer hires someone for an indefinite period or promises job security, the employer has created an implied contract. An implied contract is an unwritten agreement created by the actions of the parties involved. Such promises establish employee expectations, especially if there's been a long-term business relationship. The employment relationship is affected both by formal and informal agreements. The rights and responsibilities of the employee may be spelled out in a job description, an employment contract, HR policies, or a handbook, but they're often not.